All right, I'd like to welcome our guest this hour, criminal defense attorney Colleen Kelley. Colleen, great to see you, my friend. Colleen, we're dealing with a case here involving these two men here that are married, and they partook in somewhat of a non-traditional lifestyle, having their relationship open to others who they found online, who were down to partake. Now, the cornerstone of the defense's theory here is this secondary apartment where Tim Smith was found. This apartment being where they would have these sex parties with all different individuals from all these different walks of life. Their theory is that Tim could have been killed by any of these people, but not the defendant here. What is your main takeaway from this so far?
Hi, Cody. Thanks for having me. Yeah, I'm wondering the same thing. And while I see the defense parading out potential alternate suspects, what they're not giving us is a motive. They had the witness that connected with Tim Smith over Grindr, but it doesn't sound like they ever met up. And none of these people that they're bringing forward really had any motivation to kill him like the defendant did.
Yeah, and I just want to piggyback, about this apartment, because that's all really the defense is bringing forward here. It was reported that when they got there, leather bondage straps and all that was found on the bed and whatever else, all those different objects. With the nature of their sexual relationship and the possible extreme activities that they may have had going on in this home, is there a world that exists or a viable defense that exists that suggests something accidental, maybe erotic asphyxiation or something like that, as a viable defense?
Sure, I think that's possible, and I think that's why they're bringing it out. They think that it's a good defense. And again, while no one really had any motivation, anyone could have been there at any time. I think what's interesting is we're missing any trail of someone else actually having been there. If someone was there, and maybe they had been there previously and had kind of come back and it was not planned, but that part is, again, the missing link. But I think it also lends credibility where the neighbor is hearing screaming, and that kind of goes against the prosecution's theory that he was drugged before he was killed. That really lends itself to more of a violent encounter, an assault that did occur in the apartment.
Colleen Kelley, we always appreciate your insight, but we have to squeeze in a little break here. You're going to be sticking around for the rest of this hour. But folks, before we go to break, an update on another case we're following here at Court TV, the End Her Suffering murder case of Utah nurse Megan Sundwall. Now, the nurse was in court today for a bond hearing. Prosecutors say the nurse convinced 38-year-old Casey Terry that she had terminal cancer and killed her with a lethal dose of insulin. Investigators say Sundwall believed she was the beneficiary of Terry's rumored $1.5 million life insurance policy. Folks, it's a fascinating case. And coming up at 6 p.m. with Court TV anchor Michael Ayala will bring you an update on that Sundwall bond hearing. All right, we got to squeeze in that break now, but coming up, more testimony in the dosed and choked murder trial of Herbert Swilly. All right, let me bring back in criminal defense attorney Colleen Kelley. Colleen, Swilly choosing not to testify. Just want to get your thoughts. Good move, bad move. He's claiming he's not guilty, yet he doesn't want to explain why he's not guilty. What are your thoughts?
Well, I always think that's a mistake. All a jury wants to hear is, I didn't do it. That's what they're waiting for. And yes, there's the presumption of innocence. And yes, defense attorneys advise clients in many circumstances not to testify. In my experience, it's because A, my client can't say he didn't do it. B, is going to say something that makes him seem guilty. And those are the only reasons I don't put on a client to testify in their own defense, because that is, again, the single thing a jury wants to hear.
Right. And Colleen, as I was reading up on this case and watching some of the testimony, it seems like it's based a lot on some circumstantials. Even though the circumstances do align, it's still circumstantial evidence, meaning naturally there are going to be conclusions made by the jury that are going to be naturally jumped to, conclusions to be jumped to by the jury. Take us to law school for a second. As a defense attorney, how would you pick apart this circumstantial case?
Well, they presented motive, they presented opportunity, but they don't have direct evidence. They don't have, eyewitnesses. They don't have all of those direct evidence links to the defendant that make it a slam dunk or open and shut case, whatever you want to call it. So the jury instruction gets the jury instruction on circumstantial evidence is essentially, if it looks like this, it probably is this, and you can consider that with essentially the weight that you want to give it.
Absolutely. Colleen, always appreciate your insight. You are sticking around for the remainder of this hour. But folks, we got to squeeze in a break. Coming up, the defense has rested, but we're going to listen back to testimony from the medical examiner in the dosed and choked murder trial of Herbert Swilley. Stay tuned. We'll be right back. All right, the medical examiner going through a lot. Blunt force injury, strangled with ligature marks. Now, again, remember to our viewers, the defense has rested their case. Swilley said he will not be testifying, and we are expecting closing arguments tomorrow. Still with us this hour, criminal defense attorney Colleen Kelley. Colleen, I just want to get your general thoughts on this medical examiner's testimony. I mean, we heard her talk about the toxicology of that over-the-counter sleep medicine over 30 times on normal therapeutic amount, ligature marks, the body smelled of bleach. What are you making of her testimony?
Well, I think the testimony about the ligature marks and the blunt force trauma is particularly interesting, and that's helpful to the prosecution. Essentially, the alternate theory from the defense is that maybe one of these random stranger sexual encounters somehow resulted in potentially an accidental death. We know the couple had essentially a sex playroom, and perhaps they were engaging in some sort of asphyxiation. But I think what the forensic examiner is going to present is that this wasn't a little bit of strangulation that somehow resulted in an accidental death. This was violent. It caused, I think, a cervical fracture and some other injuries, including the blunt force trauma that she was just describing. So really lending to the theory that this was a homicide, this was a murder, this was violent, it wasn't accidental.
And Colleen, you spoke about earlier in the hour about motive. And, when I see things like blunt force trauma, specifically strangulation, that sounds like somebody really wanted to get close to you. And, really, it's not just like you walk in and shoot somebody in the room. So, I don't know. It's not looking good for Mr. Swilley here. But I want to give you major thanks, Colleen Kelley, for joining us today. Always appreciate your insight. Up next, folks, we'll head to our other trial out of Florida, where closing arguments are set to begin tomorrow in the pregnant mistress murder trial. A recap of some of the biggest moments from court there after the break. Stay with us.